And today's lecture is on the interpretation of statutes. The topic is types of statutes or classification of statutes. There are several types of statutes such as temporary statute, perpetual statute, consolidating statutes, codifying statute, fiscal statutes, remedial statutes, penal statutes, and declaratory statutes. Generally, statutes can be classified with reference to its object, method, duration, and extent of application. Let us see with the nature of the statutes are concerned, as I cited just now. Classification of statutes or the type of statutes are as follows. Statutes can be classified by object, as I said earlier, and by methods, by reference to duration and extent of application. Let us see one after another in a detailed manner. First, we will see the classification by object. What is the object of the statute is concerned? And in the classification by object, we reclassify in the following way. That is declaratory statutes, codifying and consolidating statutes, remedial statutes, enabling statute, amending statute, repealing statute, taxing statute, penal statute. And these are the bifurcation, or we don't say exactly bifurcation, but the classification under the unit, under the point of classification by object is concerned. Now we will explain or discuss each one of the above which are dealt below with these examples. Now the matter comes to the first one, where we can say declaratory statutes are concerned, which comes under the object of the statutes. And declaratory statutes may be defined as an act to remove the doubts existing as to the common law, or the meaning of or the effect of any statute. Such acts are held to be retrospective. This may happen, for instance, where the courts have been interpreting particular expression as connoting a specific meaning, which, in the opinion of the legislature, is a wrong notion of the expression. In such cases, the legislature may pass a declaratory statute declaring the correct meaning of that expression, thereby setting aside the controversy regarding the correct meaning of the expression, that is, the meaning of the expression in the earlier statutes. Then, for example, we'll see the definition of house property has been amended under the Income Tax Amendment Act 1985 through the judgment of the Supreme Court. In the same manner, the Foreign Exchange Regulation Act (FERA) is altered and written again or reiterated or replaced by the Foreign Exchange Management Act, that is FEMA, is made. Now the FEMA is a declaratory statute because earlier FERA and which is amended and some of the correction is made, and then the later statute is passed, that is the FEMA, that is Foreign Exchange Management Act, and hence FEMA is a declaratory statute. Regarding the second B point is concerned, codifying and consolidating statutes. When you say the codifying statutes are concerned, a codifying statute is a statute which presents a detailed authoritative statement of the rules of law on a given subject. The object is not merely to declare the law upon some particular subject, but to declare in the form of a code. Example, we can say under the codifying statutes are concerned, Civil Procedure Code 1908 is one of the example. The Hindu Marriage Act is 1955, if I not be mistaken over there. The Hindu Succession Act 1956, rather I make the correction here, 1956. Please make the correction if I may be wrong. Then comes to the consolidated statutes are concerned. In the consolidating statutes, it is a statute which presents the whole body of statutory law on the subject in a complete form, repealing the former statute. It is a statute which consolidates its laws on a particular subject at one place. The main purpose of the consolidating statute is to present the whole body of the statutory law on a subject in incomplete from repealing the former statute. And that is the example we can say here is the Arbitration and Conciliation Act of 1996 is an example of consolidating statute is concerned. Then comes the C, remedial statutes. In remedial statute, we will feel remedial statutes are those statutes which provides the remedy for the a wrongful act in a form of damages or compensation to the aggrieved party, but don't make a wrongdoer liable for any penalty. And this type of statutes are beneficial to the weaker section of the society. They are directed towards extending a certain benefit to the particular class of society. Therefore, they are also called a welfare legislation or welfare statutes are concerned. For example, Industrial Dispute Act of 1947, Workman Compensation Act of 1923, and Consumer Protection Act of 1986. Then other examples also we can find it. That is Maternity Benefit Act of 1961 and Industrial Dispute Act of 1947, which is already dealt. And then the later one is Specific Relief Act. Please make the correction of the specific relief. Specific, S-I-F-I-C, specific, here C should be included over the Specific Relief Act of 1897 is the example for the remedial statutes are concerned. And now we will see the enabling statute. In enabling statute is a statute which enables something to be done. It basically gives the power to do something. According to the crisis, many statutes have been passed to enable the something to be done which was previously forbidden by law, with or without the prescribing the way it is to be done. Example of this is Land Acquisition Act of 2013, Constitution of India, and Child Act of 1960. These are the examples for that kind of statutes are concerned. Then comes the amending statute. As we all know, amendment means a change in the existing law. A law is amended when it is in whole or in part permitted to remain and something is added or taken away from it, or it is in some way changed or altered to make it more complete or perfect or make it suitable to accomplish the purpose for which it was made. For example, for the amending statute, we can say Code of Criminal Procedure 1973, which is amended the Code of 1898 is concerned. That 1898 is the old code, and the 1973 is the new code. That is the Criminal Procedure Code, which is the amending statute. Then comes the curative or repealing statute. Under it, we will feel which is a statute which is already exists will be repealed by the new statute or cured by the new statute. And for this, the example we can say the Code of Criminal Procedure 1973 is repealed and reenacted by Criminal Procedure Code of of course, let me make my correction. The Code of Criminal Procedure 1973, and it is repealed, and the Criminal Procedure Code of 1898, and the new procedure code is acted, which is a curative statute. That is the Code of Criminal Procedure 1973. In the same manner, MRTP, that is the Monopolies and Restrictive Trade Practices Act 1969, is repealed, and in its place the Competition Act of 2002 is placed. Later we can see the G, that is the taxing statute. A tax is imposed for the public purpose for raising the general revenue of the state. A taxing statute is to be strictly construed. Of course, regarding that we will study in the further classes what is taxing statutes as well as the criminal statutes are to be construed or constructed strictly. But here we will see, according to the Lord Halsbury and Lord Simon stated, The subject is not to be taxed without clear words for that purpose, and also that every act of the parliament must be read according to the natural construction of its words. For example, under this taxing statute, you can say the Income Tax Act of 1961. Then comes the Penal Statute. The Penal Statute, the subheading itself says clearly, a penal statute is one which punishes certain acts or wrongs. Such statutes may be in the form of a comprehensive criminal code or large number of sections providing punishment for different wrongs. The penalty for the disobedience may be in the form of fine, forfeiture of property, or imprisonment, or death sentence, etc. And examples under these statutes are Criminal Procedure Code and Indian Penal Code is the best example under these penal statutes are concerned. And this is up to the classification by the object is concerned. Now we'll see the statutes, the classification made by method. And here the method in the sense it is a mandatory or a directory statute, or it is a declaratory or permissive statute. And the second one is, the first one is mandatory statute or obligatory statute. A mandatory statute may be defined as one whose provisions or requirement, if not complied with, will render the proceeding to which it relates illegal and void. An example for the mandatory statutes, and if you see, wherever the word shall appears in the statute, those statutes are called mandatory statutes. For example, Indian Penal Code in the Constitution of India, many other places, the word shall will come, and wherever that in any statute shall comes over there, those statutes are called mandatory statutes. If any person fails to do or follow the direction or mandatory order, then he or she shall be penalized or punished, and such statutes are called mandatory statutes. And where shall word is used over there in the provisions. And if a person did not do it, then he will be punished or penalized. And then comes the under the second category, under the not objective method is concerned, that is the directive statute or permissive statutes. A directive statute is one where non-compliance will not invalidate the proceedings to which it relates. Where may word can be used if any person did not follow the order, or then he or he shall will not be penalized or punished. That means no penalty is imposed. Such statutes are called directory statutes. In the directory statutes, the word may is used over there in the provisions. And if may means may the to do or not to do, but the punishment will not be there or the penalty will not be there. And wherever such may word will come under a statute, and such statutes are called directory or permissive statutes. Regarding the third classification by reference to the duration is concerned. And when you say the duration, then will comes the temporary and permanent or perpetual statutes. When you see the temporary statutes are concerned, this type of statutes are statutes which are in existence for a known period. Such statutes are called the temporary statutes. And life period statutes is fixed one. In simple words, this type of statutes, this period of operation is fixed by the statute itself. The statute is temporary in nature. The best example for this is Financial Act, which is made every year, whose period is only for 1 year. Then comes and the second one is permanent and perpetual statutes, where no time limit is fixed. The statute is permanent in nature, and the best example is the Indian Penal Code, or there we can say the Indian Contract Act or Income Tax Act, and like that. And when you see the dictionary meaning of the term perpetual is forever. Therefore, perpetual statutes are those which remain in force forever. And the example already I cited over there, that is Indian Penal Code, Indian Contract Act, Income Tax Act, until it will be said as a repeal, but there is no fixed time period for the those statutes are concerned. Then comes the fourth one, that is the classification with extent or reference to the application is concerned. And in the reference to the application, we can divide it the two types of statutes, that is the public statutes and private statutes. When you come to the matter of the public statutes, an enactment of a legislature that affects the public at large throughout the entire territory or a state or a nation which is subject to the jurisdiction of the legislature or within the particular subdivision of its jurisdiction. And general law, that is also called public act or public statutes. Example, Constitution of India, IPC, etc. are said to be the public statute, where it is refers to the public at large. And then comes the second category under the classification to the extent of the application is concerned, that is the private statutes. And here the statute that is enacted by the legislature on the application of an individual, a municipality or a corporation which relates only to the interest of the applicant. For example, under these private statutes, we can say that is law of contract, labor law, commercial law, corporation law, or competition law, etc. Thus, we can classify or categorize the type of the statutes in a different way in this class we dealt it and this is the end of this class. Thank you very much.